while both scholars' citations peak in the 10th century AH, they have very few sources from this century in common, I believe 2. Again, one might attribute this to each author's selective citation of sources that support his own case, but I believe there's more going on. Of Hamzawi's 10th century citations, no fewer than 7 are from the fatwa of the Ottoman Sheikh al-Islam, Abu Sa'ud Effendi. This is perhaps not surprising, since if one consults collections of Abu Sa'ud's fatwa, it emerges that he issued a large number of fatwas, unambiguously endorsing the validity of contracts of hire for reciting the Quran. What may be more surprising is that Ibn Abidin never mentions him at all, not even to refute him. And the difference does not simply involve Abu Sa'ud as an individually, but arguably Ottoman Sheikh al-Islam as a category. Al-Hamzawi also cites 2 passages from Ibn Kamal Pasha, meaning that of his 13 nuqul from the 10th century AH, a whopping 9 are from Ottoman Sheikh al-Islam's. Context, it may be significant that Ibn Abidin states briefly but firmly that judicial appointments by the Ottoman sultans require judges and muftis to adhere to the sahih of the madhab. It is an unspoken but almost unavoidable implication that, given his vigorous assertion that the sahih of the madhab always rejected contracts of hire for Quranic recitation, in his view, Ottoman appointees were obligated to diverge from the opinion of Abu Sa'ud. In Ibn Abidin's views in this epistle are deeply and overtly informed by those of Birkavi Effendi, and as Katerini Evani has observed, Birkavi devoted much of his adult life to refuting the supposed legality of many of the practices Abu Sa'ud officially endorsed. So, at least on this one issue, then maybe we can see Birkavi as representing a little bit of a countercanon to the one invoked by Hamzawi. So that's really all I have, my hope is that this is of interest just in the extent to which, you know, even though in content there's a lot of overlap in these 3 epistles, you would not think they belong to the same school of law just in terms of, you know, sort of the interpretive techniques that they believe are available to them and the canon that they're drawing on. So thank you.
So, very good questions. Any chance you looked at Ibn Abidin's citation practice in light of his other essay,
Not directly, no. But I mean, I do think that, yeah, I mean, you know, like, I think you could productively do that. And it, you know, like, I think it's, you know, like, say, not a coincidence that he cites Ibn Qutb so prominently. Like, he definitely has a picture of sort of like what the chronology of, you know, sort of like declining, you know, sort of scope of his jihad was. So.
All right, thank you for that really interesting presentation. In terms of Ibn Abidin, I know that Lu'ay al-Khalili published a study of the sources he draws on that may be useful. It came out not that many years ago. I forget the title, but I can look it up. 2 questions about names. The grandson of Ibn Abd al-Wahhab, I assume, is Abdurrahman ibn Hassan.
Yeah.
And Mr. Hamzawi, whose collected works or Rasail were published like a year or 2.
Yes, although I wasn't able to get my hand on the new edition, so I am using the old edition, but yes.
And thank you. And my bigger question is about ʿANAFI. Do you get a sense that something is going on? You know, it's more than just individual idiosyncrasy. In North Africa, I mean... I
don't know, because the thing that really intrigues me about it, and again, I don't know if it's just because, you know, I'm interested in this topic, I don't usually work in this period, right? So I don't know whether the degree to which he was unfamiliar to me is just me. But like, it seems as if, you know, if you look at what's readily available written about him, and it's understandable. I mean, like he's this really important Algerian figure and, like his work on military reform, obviously sort of, with its relevance to colonialism and so forth, it sort of overshadows the rest of his oeuvre. But what really strikes me is that both Ibn Abidin and al-Hamzawi are sort of overtly making arguments about methodology, right? Like there's a meta level on which each of them is not just writing about whether you can, pay someone for reciting the Quran. They're arguing about how to argue, right? Whereas Ibn al-Hanafi, who's doing all these things that, like, to me, it sort of feels as if in the 19th century, this is pretty far out there, right? Like it's, late, but also sort of before Salafism and stuff like that. He just seems completely unself-conscious as sort of like, okay, I'm gonna like, make all these arguments based, like directly on, sort of analytic judgments based on hadiths and all of this stuff. And like, it made me wonder, like, it doesn't seem as if there's something already out there sort of talking about what circles he was moving in. And it seems to be the case he was very well received both in Algeria, in Tunisia, where he spent some time, and in Egypt. So like, it doesn't seem as if people were upset.
But from these passages, it's for me it's unclear what, for example, Ibn Azrin and other Hanafi authors mean by at-tilaba, because if we look in real life, there are two types of at-tilaba. The first one for in religious events in Uzbekistan, for example, if somebody dies, usually in third day they invite imam, and there is a religious event, and imam recites some Quran, some part of Quran, or maybe some people order imam to complete the whole Quran, the 30 parts of the Quran. And the second one, usually in Ramadan. And in Ramadan, now in Uzbekistan, almost in all mosques, there is this Khatm Quran. And we do not know what Ibn Abi means by at-tilaba. Is this in Ramadan or in?
No, it's definitely in a funerary context. Sorry, it's like here I was just sort of looking at methodology, but like he talks in quite a bit of colorful and probably, detail about the actual practices, and he's talking about after someone dies, for sure.
It's actually, I don't know, quick follow-up, but follow-up to this. So lots of WAF documents, for example, provide for a Quran reciter to recite and they give them a certain stipend. Does he distinguish those?
He does, which is interesting, and I actually wanted to ask Katerina, but maybe, I know time is short, but like, so Ibn Abidin's, that seems to be too hot to handle, and I don't know if it's just sort of sincere. One part of me, so Ibn Abidin is sort of like the imaginary, or possibly he's real, I don't know, but like there's the interlocutor who's sort of driving the argument, and the interlocutor is sort of like, are you saying that all the al-Qaf are invalid? And he's like, no, right? And he sort of makes a difference, which seems sort of like, it seems to sort of cry out for a sort of sociological or class-based, interpretation, where he's making this distinction between, like sort of disreputable Sufis who come to sort of recite Quran on a more or less fee-for-service basis after deaths, and, like the sort of supposedly more respectable people who Ibn Abidin sort of says, well, they're pious people who would be reciting the Quran anyway, you're just supporting them rather than engaging in a quid pro quo, transaction. It's unclear to me because Birkavi, I think, was willing to go after the al-Qaf.
I don't remember exactly, I wouldn't say.
Okay.
I wouldn't, have to look,
Because like the interlocutor is sort of like, your guy Birkavi says the walks are invalid, and then Ibn Abidin is like, no, that's not true, and I wasn't sure what the case was.
You allow me?
Yeah.
I mean, I think, I haven't read the Risala, But from what I know of kind of doctrine on this, or I believe this kind of doctrine, is they make a distinction between a risk and.
Yeah, no, I mean,
Yeah.
definitely, I mean, I didn't really go into, yeah, like, absolutely. That would be a different paper, but, yeah,
So the waqf is a risk, it's not much.
not according to Abu Saud. I mean, you know, like, when he has at least one fatwa where he's directly asked, is this a salah or is it an ujra? And he's like, yeah, it's an ujra because if you don't get the work, you don't get the pay, you know, and, I mean, he's willing to draw, you know, juristic, you know, implications from the idea that this is actually a wage, right? So, you know, they're genuinely different times.
Thank you so much. No. Well, I have no presentation.
Presentation, no?
No, no presentation. Okay, well, good afternoon, and my comments going to be very brief. I know we're really behind time, so I'm going to share with you some preliminary conclusions about things I've been working on. First of all, I'd like to thank the Imam Bukhari Institute for hosting us and for all the participants for sharing this scholarship. So, in my presentation today, I'd like to share a few conclusions about modern Egyptian legal history, especially the institutional restructuring in the late 18th and the early 20th centuries, and the Hanafi legal tradition through discussions in relation to two court decisions. First, the Cairo Mixed Court in 1886, and second, the Islamic Supreme Court in 1929. So the plural legal regime in the 19th century Egypt included 5 categories of courts with a reliance on a mix of legal codes. These included al-Mahakim al-Shar'iyya and the Milli courts, and this included Roman Catholic, Armenian Catholic, Armenian Orthodox, Coptic Orthodox, Greek Orthodox, Greek Catholic, Hebrew, and Protestant tribunals. The third category is mixed courts, which were established in 1876, and they dealt mainly with property, debt, and financial issues with a foreign national interest. They replaced the mixed councils, and they dealt with cases between Egyptians and foreigners earlier in the century. The fourth category is in Mahakim al-Ahliya, or the so-called national courts, and these were established in 1883. The fifth category of courts was the council courts, and were based on capitulatory privileges by which nationals of some states or empires had privileges to litigate their cases in their own consular services. So this plural legal order has been celebrated and generally understood as evidence of the history of cosmopolitan Egypt. However, the more I read about this system and its reception in the late 19th century, it raises a set of questions about the sociology of the system and its political consequences for Egyptians. It also allows us to better appreciate the move to completely adopt civil law in the early 20th century and the Egyptians' nationalist insistence on the need to unite the Egyptian legal order under one civil legal system. So on the 17th of March in 1888, Majalat al-Huquq is a very rare legal journal published in Egypt in the middle 19th century, published a critical editorial on legal and judicial pluralism in Egypt. The key concern by the editor is the transformation of capitulations into a system of law and courts. And these capitulatory institutions seized, according to the editor, seized more power and authority that was never intended by the Ottoman capitulation system. More seriously, these legal and judicial systems became more powerful than the local state laws. The editor specifically mentioned the legal councils various patriarchs, Roman Catholic, Coptic Catholics, Assyrian Catholics, Mennonites, Caledonians, and others. In addition, the Jewish courts at various Jewish religious authorities, the so-called ḥANAFI, these also are considered to be an added layer to this order. According to the editorial of Majalat al-Huquq, the different legal regimes that govern the affairs of the residents of the local government in Egypt resulted in contradictory justice. It is, according to the editor, it is a financial burden on residents, and the judgments will vary based on the courts where individuals' claims were filed. Additionally, Egypt introduced mixed courts in 1876 to govern the affairs of foreign nationals, either among themselves or between them and the local residents in Egypt. Added to the system is the council courts, as indicated earlier, were designed to resolve disputes among their own nationals, civil and criminal. So the editorial was very concerned about the system. This is very early on in the really late 19th century, in which that position seems to be secured, and were articulated repeatedly that having a plural legal order in Egypt was not actually something positive at all. So the editorial said that this system was a divergence of the previous order that even existed prior to the Ottoman Empire. So according to the editor, to the key editorial piece here, it says that any country that does not keep a unified legal and judicial order to govern all people, regardless of their specific nationality, cannot obtain unity or obtain this power and authority that comes with unity, as observed in European states. The editor argued that if time is not suitable for a unified legal order in Egypt to govern all people, regardless of their nationality, it's high time for Egypt to unify its judicial order, to resolve its civil, commercial, and criminal disputes. It should be a single court, the editor argued. It should be a single court mode and ban other courts with specifically religious jurisdiction, what he calls al-ḥANAFI, from interfering in these cases. So again, this was articulated in the very late 19th century, before even the rise of the very strong nationalist impetus to actually change the system, with the rise of civil law in the Sanhoris in the 1920s onwards. So according to the editorial then, these religious courts will have a jurisdiction in cases that are innately quote-unquote religious, بطبيعتها الدينية. Religion is germane to it, and do not have quote-unquote legal entanglements with other issues based on Ottoman farmans and Khedive decrees. The interference of these courts in disputes that are not purely quote-unquote religious exposes all subjects for all risks of greed and tyranny, and the responsibility of the heads of these religious communities. The editor emphasized that it is established that the interference of these religious councils in non-religious matters caused complaints and vested rightful claims. So this is a very important, I think, piece to understand in the legal history of modern Egypt, that seems to really think that having a plural legal order was functioning well, at least received uncritically by most of those involved in the legal order. I would like to suggest three things here: that the jurisdictional demarcation of the courts should not be uncritically accepted as a statement of how these courts actually operated in this plural legal order. Instead, I would like to argue that the rise of the so-called takhsis al-qada or tanazu al-qada, as a lot of texts have been published, especially in the 19th century, early 20th century, on the subject of takhsis al-qada and all debates surrounding it, as evidence of the difficulty to imagine and neat jurisdictional fault lines among these judicial institutions. Second, I would like to assert that the labeling of these courts, محكمة شرعية, محكمة أهلية, محكمة ملية, محكمة مختلطة, is also indicative of a new logic underlying these institutional transformations. So the need to qualify a محكمة that usually is called القضاء الشرعي or just القضاء as محكمة شرعية, for me is a new logic that comes to describe new commitments in these institutions. So for me, the Islamic courts are now not simply a continuation of previous institutions. They are now reimagined within a particular framing of religious courts. Almost all writings that I'm familiar with or consulted in my work by judges or lawyers in Islamic courts on the history of their institutions in Egypt stressed the institutional transformation of al-qada throughout Egypt, throughout Egyptian history. They understood that how gradual legal change of law and the emergence of multiple court system affected their operations and relevance in the emerging legal order, especially with the complication of British colonialism. Okay, so now we move to one legal case that I'd like to discuss, and maybe a second if time allows. So this case was published again in Majal al-Huquq on March 6, 1886, in which the parties, somebody by the name Muhammad Big Ratib, and the other party is a Greek national. I can say his first name is Christophe Benny, and then Bistitutus, something like that, but I'm going to just the Greek national. So before the mixed court in Cairo, this Greek national filed a suit seeking payment from Muhammad Big Ratib. Muhammad Big Ratib was the son of the late Ismail Pasha Ratib for bills of exchange with the total value of 13,000 Egyptian pounds. The court issued two decisions in absentia in favor of the Greek national. The first was issued in June, and the second was issued in January of 1885. Well, the guardian of Muhammad, Muhammad was underage. His name is Uthman Pasha Ghalib, is his maternal uncle, filed a set of counterclaims before the court, seeking basically to dismiss the case and that he's not liable for these bills of exchange that he signed as a child. So the central question in this case is whether bills of exchange that were signed by Muhammad Big Ratib were legally valid. As a minor, Muhammad Big Ratib was 16 years old and could not have the legal capacity, according to his now guardian, to dispose of such financial responsibilities. The value of that sum of money is almost $1 million in terms of how, according to the sources we received. So the guardian argued that the determination of whether Muhammad Ratib had the legal capacity to carry these financial transactions should be based on Islamic legal tradition, Shara al-Islami. This is, again, the entire case is governed by now civil code in mixed courts. That's very important here. So the guardian is arguing in the mixed courts that the law that should govern that case should be Islamic law. He maintained that article number 190 from the civil law, Al-Qanun al-Madani, stated, quote, absolute or restricted legal capacity in contractual agreements is subject to the laws of the nations to which the contracting parties belong, end of quote. So exploring the authoritative legal positions of Muslim jurists on the age of legal capacity, the guardian's lawyer argued that there are two levels of assessment to reach a determination. First, personal with material consequences. Second, practical with civil liability. The first type is the appearance of the material signs to indicate manhood, and according to Abu Hanifa, the founder of the Hanafi school, it is the age of 18 for boys and 17 for girls. However, the students of Abu Hanifa argued that the age is 15 for both boys and girls. The legal majority for Abu Hanifa is the ability of a person to legally transact with his money as he wishes, even if he did not carry out religious duties. So the case then before the court regarding Muhammad bin Ghalib and based on the documents submitted to the court, which includes a decision, as I mentioned, in 1885, includes a lot of documents and bills of exchange. I'm just going to skip here to just make sure that we go to the key details I wanted to share. So upon the death of Muhammad bin Ghalib, the father of Muhammad bin Ghalib, he came under the guardianship of his maternal uncle, and for the reasons I mentioned earlier, that he was underage, Muhammad bin Ghalib was argued before the court that he did not have the legal capacity nor the valid qualifications to sign these bills of exchange. So, and based on the positions of Abu Hanifa, which required 18 years of old for legal majority, Muhammad bin Ghalib did not, according to the lawyer of the defendant here, of the plaintiff, did not reach the age of 16 years old, as established from his birth certificate. Based on the position of Abu Yusuf and Muhammad al-Shaybani, Muhammad bin Ghalib, although he reached puberty, he did not reach the age of legal majority and legal capacity to engage in such financial transactions. The plaintiff suggested a set of counterclaims to establish that Muhammad bin Granted was transacting with the permission and the knowledge of his father. And as a result, it is an acknowledgement of his legal capacity, and as a result, hopefully pay that money back. The plaintiff stressed that Muhammad bin Granted divorced his wife in Rajab 1300 without the permission of his father. If Muhammad bin Granted did not have the legal capacity, he would not have been able to divorce his wife, right? The defendant also, in response to this claim that Muhammad bin Granted, once he reached the age of puberty, he was freed from his father's authority in relation to his personal status affairs, but not his financial and property affairs. The plaintiff provided another occasion that indicated that Ismail Pasha Ratib joined his son in two separate contracts, one in 1881 and the other one, I think, in 1882. And this suggests that Ismail Pasha Ratib himself acknowledged the legal capacity of his son by including him in transacting these two contracts. The defendant responded that a contract or two cannot be considered evidence of legal capacity, especially when the father is permitting his son, who is under his guardianship and his authority to sell or buy specific commodities without being construed as an acknowledgement of legal capacity of his son. And that position is supposedly taken from Al-Fatawa al-Hindiya. In these two contracts, underlined by the plaintiff, the defendant insisted that Muhammad bin Granted appears as a party to the contract with the father, not a third party. Furthermore, the plaintiff argued that the legal capacity of Muhammad bin Granted is known because he had carried with him a seal with his name on it, with the knowledge of his father. This personal seal was misplaced by Muhammad bin Granted, and the newspapers actually issued a notice to allow anybody who found it to actually return it to its rightful owner. The defendant responded that the custom in Egypt is that everyone, regardless of their reading ability, acquire a seal. Having a seal maker to produce a seal is an easy and smooth process. It is not an obstacle for Muhammad bin Granted, whether his father was aware of it or not, to acquire a seal for his personal and private correspondences without granting him legal capacity to dispose of his property. As a result, this cannot be used as evidence that Ismail Pasha Ratib, the father of Muhammad, acknowledged that his son has legal capacity or somehow is permitted to actually take on these bills of exchange and money and seal them with his seal. In addition, the plaintiff asserted that Ismail Pasha Ratib, the father, tacitly affirmed the legal capacity of his son. Thus, he did not request the cancellation of these bills of exchange once he became aware of them, signed by his son, or took any precaution that his son would not repeat this again. The defendant responded that Ismail Pasha Ratib was not aware of the procedural rules of the mixed courts due to their recent introduction in Egypt. Instead, Ismail Pasha Ratib relied on Islamic law, which maintains that the son does not have the legal capacity to dispose of his property without his permission. Ismail Pasha Ratib maintained that he was only required, based on his guardian authority, to appeal to the Khedive, who possessed both the judicial and administrative powers, to evict his son from Egypt. That actually happened. And the Khedive approved the removal of his son by sending him to Beirut and then to Switzerland to study law, hoping that that would bring him to the right path and realize the locus of his interests. The defendant revealed that Muhammad bin Granitib's conduct is disturbing. He disclosed that the case before the court is only one of the many. He had signed in these very same circumstances other bills of exchange with the prohibitive sum of money totaling almost 100,000 Egyptian pounds, and then 3 million, which is around 3 million Swiss francs in one single year. It is important to ponder this bizarre conduct from a 16 years old, which enabled some individuals taking advantage of his irresponsible and reckless behavior to undermine one of the most honorable families in Egypt. How come a 16 years old boy signed such bills of exchange, let alone the strong implausibility that he had received such sums of money? The owners of such bills of exchange are not justified to grant these huge loans with a simple statement and without any collateral from the borrower. After this presentation, the defendant explained that the bills of exchange signed by Muhammad bin Granted should be considered invalid this position is supported by Islamic law, whether the position of Abu Hanifa or his students, and affirmed by the other three Islamic legal schools. This position is also sustained by rational argument, the principles of justice, and French civil law. The article number 503 from the civil law states, quote, transactions that were undertaken before introduction, Hajj al-Safi, can be invalidated if the reasons upon which interdiction was granted were prevalent when these transactions were conducted, meaning the conditions by which Muhammad the Caliph signed these bills of exchange obviously was known to be a reckless void, and basically making him sign these bills of exchange makes that invalid. Anyway, so the court issued a judgment on January 9th, 1886, in which Muhammad actually had to pay the money. Wassalamu alaikum. Yes.
Thanks, that was really interesting. A clarificatory question. So in the article in Majallat al-Hukuk you opened with, the author seems to be criticizing religious or sectarian reports on the one hand, but
Yes.
later on in your presentation, you also seem to be making a distinction between religious and non-religious domains.
Correct.
So in the mid-19th century, was this new class of legal professionals actually seriously countenancing the abolition of Sharia courts and the unification of, I mean.
Yes, that early, you're right. His name is Amin Shumail. I think he's an Armenian lawyer. I think so. Comes from a very well-established merchant family. Had a business in Liverpool. There's a famous, I think, story in which he's selling the Egyptian cotton, and then one of the ships sank before the pier in Liverpool, and all the business went out of order. Anyway, he went to went to the French legal school, and then became a lawyer in Egypt and established this magazine. But he was not against Islamic courts, but he just saw any religious course of any kind is a problem that need to be abolished even then, without even the nationalists just come to the picture at all.
It's very relevant.
Correct. Okay, break and coffee in 10 minutes. Thank you.
of our workshop.
Welcome back. This is our last session of the day. We're gonna have two presentations only, so we have plenty of time, inshallah, to ask questions and comments. Our first presenter is Dr. Ḥanafi. The title of this presentation is Ma'rudat and showed universality, historical contingency, and how of their students. Without further ado, thank you, Bob.
Thank you. Of course, I would like to start by thanking the organizers, especially the Imam Bukhari Institute team, Şahbettin Ziyadov, Otabek Mohammedia, and others. And of course, Sami Ayub for putting up this excellent workshop in this beautiful city. I greatly benefited from the excellent papers since yesterday. I learned a lot on different aspects of the Hanafi doctrine and its history. Actually, I learned things that I had never heard in this workshop. So I'm really grateful to all of you for all your contributions. My paper concerns the development of Hanafi doctrine and its implementation in interaction with the shifts in the political conditions in the pre-modern Ottoman Empire. In the longer version of this paper, I will dwell on Ottoman state formation, development of governing institutions, and incorporation of ulama into the Ottoman government and bureaucracy, and discuss how this affected the development and implementation of Hanafi doctrine directly or indirectly. Today, I will just focus on the state's direct involvement in the processes related to the production and implementation of Sharia knowledge. I suggest that the cooperation of ulama, scholar bureaucrats, the ulama who were affiliated with the Ottoman government, and the sultans, the cooperation of scholar bureaucrats and the sultans brought about the rise of a new type of legal authority, combining scholarly and political authorities to articulate or make legal norms. This was reflected in a new hybrid genre that I call imperial fatwa, that is fatwa endorsed by imperial decree. The work Ma'ruzat of Abu Suud, which was posthumously compiled by an anonymous compiler, aimed to bring together imperial fatwas. I will explain what I mean by imperial fatwa in a moment, but now I want to go into some detail and provide the context to explain what I mean by imperial fatwa. So this is, I have to say this at the beginning, this is still work in progress. I will appreciate any kind of feedback you may provide. I want to start with a comparison of Sharia knowledge and statute law. What is Sharia? The question of what is Sharia is not an easy question to answer. A number of different answers to this question have been proposed. For example, there is the tendency of seeing Sharia in concrete terms and conceiving it as consisting of well-defined exact rules on particular points, almost comparable to modern codified law. On the other hand, on the other extreme, there is the tendency of seeing Sharia in abstract terms, consisting of essential principles derived from the scriptural sources and nothing in particular rules. Another line of disagreement concerning Sharia is who produced Sharia and on what authority. Some claim that scholars having the knowledge of scriptural sources interpreted them and produced Sharia knowledge in the name of the Muslim community and for the voluntary use of Muslim individuals. As such, Sharia included multiple and diverging opinions of different qualified scholars. Other researchers directed attention to the critical importance of political power for the existence of Muslim community and the wielders of power in the production of laws. For these, Sharia included not only scholarly opinions, but also the decisions and acts of rulers. My discussion today is related to these debates about the question of what is Sharia, but rather than making an overarching argument about this question, I focus on a particular appearance of Sharia in a particular period. Here in this slide, I defined some general criteria for comparison between Sharia and statute law. I am aware that my characterization of Sharia and statute law as ideal typical, aiming to develop them as abstract terms. It is of course possible to find cases that might not perfectly correspond with my characterization. My purpose is to provide the context to explain the hybridization of Sharia knowledge with statute law and the rise of a new type in its own right, imperial fatwa, not as a divergence from the mature types of mature genre types. In terms of authority, Islamic Sharia knowledge derives its authority from reliance on scriptures, the Quran and the Hadith. On the other hand, statute law derives its authority from being the will of the political power. In terms of actors, in the production of Sharia, ulama, Muslim scholars are always the main actors, although there are some other actors involved. I want to underline that I am not taking sides in the debate who produced the Sharia, but for the sake of my own argument, I want to highlight that ulama in every case of Sharia production was involved and was one of the main actors. On the other hand, in the production of statute law, the wielders of political power themselves or the groups acting in their name produce laws. In terms of audience, Islamic Sharia addresses Muslim community and Muslim individuals, while the statute law addresses the subjects of the political power. The statute law applies to individuals or groups within a jurisdiction governed by that political power. As for discourse, generally speaking, Islamic Sharia knowledge has a universal discourse. These Sharia normative statements are meant to be universal and timeless, although they concern, although we can understand in some cases their relevance with particular contexts. On the other hand, statute law is by its nature historically and geographically specific. In terms of content, Islamic Sharia knowledge consists of the opinions of different scholars. They could disagree on particular points and could produce divergent opinions. As all these scholars enjoyed the same authority and there were not a higher authority to select among the opinions, these opinions all had the status of probability. Thus, Sharia knowledge was probabilistic and pluralistic. On the other hand, statute law offers definitive and single rules on each problem. Implementation. Being probabilistic and pluralistic, Sharia knowledge, the product of scholars, theoretically, without any external intervention, is not binding. It's up to every Muslim individual to follow one or another opinion from multiplicity of opinions. On the other hand, statute law relies on the authority of the government and binding on all within its jurisdiction. So in short, it is possible to identify essential differences in the basis, development, and application of Islamic Sharia and statute law. Sharia law is derived from scriptural texts and interpreted by religious scholars for a universal Muslim audience, emphasizing timeless principles. In contrast, statute law is created by political authorities, tailored to specific historical and geographical contexts, and applied to the population governed by those political entities. I suggest that imperial fatwa is a hybrid genre that mixes Sharia knowledge with statute law. First, fatwa. We can take fatwa as performative and textual genre for the articulation of Sharia opinions. In a typical fatwa process, a Muslim individual comes to a scholar and seeks an answer for a question. Muslim scholar either performs independent reasoning, ijtihad, or select one of the opinions of past scholars and provides an answer to the question. In the second case, taqlid. The scholar may consider the particularities of the situation of the questioner, but articulates his answer in abstract terms. For example, in the Ottoman fatwas, typically the real names are replaced with anonymous names, such as Zayd, Amr, and Hind, and other particularities are eliminated, and the issue and answer is articulated in abstract and universal terms, just to underline its general applicability. The fatwas have the claim of being relevant in different times and locations. It's optional to follow fatwa. The questioner or others presented with the fatwa have the right to follow or disregard it. On the other hand, imperial fatwa is not optional. The state power endorsed it. Those who were subject to this state power were required to abide by the order of the imperial fatwa. In the case of imperial fatwa, typically a top scholar bureaucrat, mostly chief jurist, but not exclusively, may select an opinion and presents it for approval. The Sultan issues an imperial decree and makes it a law. The most famous example of this is the case of cash waqfs in the Ottoman Empire. In 1545, the chief judge, Çivizade Mehmet Efendi, proposed that the practice of instituting cash waqfs that prevalent in the Ottoman lands did not accord with the authoritative opinions of the Hanafi school and asked the Sultan to endorse its prohibition with an imperial decree and make it a law. This became a law and the construction of cash waqfs became banned. This affected many people on the ground and caused them to react and request the change of this law. Then the chief jurist, Abu Suud, and some other dignitary scholar bureaucrats would put forward an alternative opinion, which could be justified with the established conventions of the Hanafi tradition. In 1548, the Sultan issued a new imperial decree, but this time allowing the construction of cash waqfs without any hindrance in the Ottoman lands. In this situation, the first opinion, the prohibition of cash waqfs, continued to be acceptable with the juristic standards. It's still a fatwa, an acceptable, a legitimate fatwa, but it lost the chance of being implemented in the courts in the Ottoman lands with the state sanction. It appears that the cash waqf debate and the relevant acts was a turning point. In the following period, Abu Suud and other scholars proposed some opinions to be endorsed by the imperial decree so that they became at the third, namely 1595. Now I want to read the introduction of Ma'ruzat, it gives an idea about what the compiler thought that Abu Suud wanted to achieve by drawing imperial fatwas. And also we can get an idea about the compiler wanted to achieve by composing this work. So the compiler presents this work with these words. This petition is presented by a devoted admirer to the Sultan, esteemed for his noble lineage, unwavering moral rectitude, and boundless generosity. Previously, the late chief jurist, Abu Suud Effendi, proposed to Sultan Süleyman the Magnificent the idea that in order to ensure preservation of religious and governmental order and orderly management of the affairs of the realm, it is required to act in accord with the opinions of particular jurists, namely, that is, prioritizing their opinions over those of others on certain matters. Consequently, the Sultan issued a decree endorsing this idea and commanded its implementation. Subsequently, governors and judges have adhered to this command. However, with the ascension of a new Sultan, bringing renewed vigor to the throne of the Sultanate and the garden of the Caliphate, uncertainty has arisen regarding the Sultan's directives on these matters. Such ambiguity complicates matters. I hereby present some of the above-mentioned issues seeking clarification through imperial decree. So in other words, the compiler says Abu Suud presented some issues, some jurisprudential issues to the Sultan with multiple opinions about them, and the Sultan chose one of these opinions, made it a law with an endorsement by Ferman, and he says, the compiler says, now a new Sultan became enthroned, and I want to present these cases to you, some of the cases which Abu Suud dealt with, and requests again a Ferman endorsing them. We don't know if the Sultan endorsed this work as an imperial qanun or as an imperial law or not, but afterwards, this work became copied many times, actually was treated as if it was endorsed by the imperial decree, because after all, the issues, the compiler presented his work as consisting of the issues that had once been approved by the Sultan with a Ferman. So what is the content of the Ma'ruzat? Here is the table of the contents in most copies of it, with my translations and annotations. The work includes fatwas about diverse topics, including prayers, charity, marriage law, booty, non-Muslims, fugitive slaves, disappeared persons, endowments, transactions, procedure in the judicial court, witnessing, judicial hearing, usurpation, distribution of salaries, leasing and renting. So this is all of the topics in most copies. It is a long list, but it is not comprehensive, which means that the effort to make laws out of the jurisprudential knowledge was not a systematic effort to cover all Sharia knowledge, but was directed to some of the issues. And the organization is also kind of disjointed. It doesn't, it starts with Kitab al-Salah and Kitab al-Zakah. It resembles to the jurisprudential works, but towards the end, it becomes kind of mixed. It is not very well organized. So far, I commented on imperial fatwa and maruzat, but however, I am not sure if we can categorize all fatwas in this work as imperial fatwa, although the compiler wants us to consider all of them as imperial fatwa as I defined it. In my opinion, not all of the issues in the maruzat were not presented to the Sultan for him to choose among multiple authoritative opinions. Not all the issues were like the case in the debate about the cash box. So I identified some types of the cases, 5 types, let's say. So in the first type, which is a typical imperial fatwa type, the Sultan makes a selection among multiple Hanafi opinions. The example of this is the issue of who pays the blood money in the case of a murder whose perpetrator is not known, the owner or the renter of the place where the murder takes place. Presented with the different views of Abu Hanifa and Abu Yusuf, the Sultan preferred Abu Yusuf's view, and the renter pays the blood money. So this is a selection among multiple opinions. So the second type, Abu Suud answers a question about an issue about which multiple Hanafi opinions exist by referring to a particular decree about this issue. Or in some cases, he says that the judges are commanded, prohibited, or permitted to act so and so, without specifying the decree. The example of this is the question of the permissibility of completing a marriage contract without permission from the guardian. Abu Suud answers that quote, in 1544 to 1545, it was commanded that the judges do not approve marriages without a permission from the guardian. So in this one, the Sultan, I'm not sure about this, but in my opinion, was not involved in this particular fatwa process. He issued an administrative decree regarding the marriages, which happened to be according with one of the jurisprudential opinions. When Abu Suud was later asked about this issue, he referred to this administrative order. If my assumption is true, there was not a question and answer situation involving the Sultan in a typical imperial fatwa process, as I defined it. But the result was the same as the one in the process of imperial fatwa. The fatwa gained the force of statute law for it accorded with an administrative order. The third type is the Sultan institutes a rule for a topic that the jurist had not articulated opinions. The Sultan was requested, the example of this, the Sultan was requested to institute a statute of limitations, and the Sultan ordered the case is delayed more than 15 years will not be heard. This took place in 1550. In this case, the Sultan doesn't make a selection, but uses his power to institute rule in the areas which are intentionally or unintentionally left unregulated. So the fourth type is Abu Suud answers a question on an issue not discussed by previous Hanafi jurists with reference to the imperial decree. So it is a question of Kanun, let's say, but it was asked to the Abu Suud, and he provides an answer. So we can put his fatwas about tapu rights and fees in this category. Here, Abu Suud, in fact, steps outside the jurisprudential tradition and assumes a bureaucratic persona and speaks as a jurist of the state, as a jurist of the Kanun. In this case, Abu Suud doesn't invoke statute law to solve the problem of plurality within the Sharia knowledge, but rather he acts as an interpreter and articulator of statute law. The fifth type, which is not a type actually, the Abu Suud and other jurists' fatwas, not referring to the imperial decree. The compiler of Maruzat or other contributors added some cases that do not directly or indirectly refer to the imperial decree, but they probably had reasons to include them in this collection. But I need to undertake further research to comment on them safely why they were included in this collection. To wrap up, I can say that in conjunction with the ultimate efforts to establish a centralized administration, ulama became incorporated into the government and bureaucracy. The result of this process was that ulama, scholar bureaucrats, had more powers in administration, education, and legal system. From the perspective of the executive institutional structure, Sharia became more important. The state power was harnessed for the implementation of Sharia, probably to an unprecedented extent. However, with all these, the executive authority, including scholar bureaucrats, undertook steps to turn Sharia knowledge, which was probabilistic and pluralistic, into law. In this presentation, I focused only on one of these steps, which is the Sultan's involvement in the process of selection among multiple opinions on particular problems and instituting this selection as law. I suggested to call the textual product of this process imperial fatwa, a new genre representing a hybrid authority combining scholarly and governmental authorities. I presented Maruzat as a text including some examples of imperial fatwa, mostly spearheaded by Abu Suud and to a lesser extent by others. Thank you.
Thank you. We have some time for questions. Anybody?
Question about your initial chart where one of the contrasts was Sharia as being sort of like for all times and places as opposed to like state law being sort of jurisdictional, like, and I sort of wondered if you could say anything about, is the authority of an imperial fatwa of this hybrid kind sort of like understood as something that applies to like people under the jurisdiction of like directly under Ottoman rule, or is this understood as something that had, you know, sort of partakes of a scholarly authority that's enhanced for like all Hanafis wherever?
So this is a good question. Actually, in one of the cases mentioned in the Maruzat, this issue of the extent of the jurisdiction of the imperial fatwa is questioned. Particularly the issue of the adoption of the Shafi'i mazhab in the Ottoman lands, where it says in Anatolia and the Balkans, the adoption of the Shafi'i mazhab is not allowed. So this shows that the imperial fatwa, these fatwas mostly concerned the Anatolia and the Balkans, or they meant them to be implemented in the courts under the Ottoman authority in Anatolia and the Balkans, not beyond, because particularly there are some references to this geographical specificities in this country, in this geography, referring particularly to Anatolia and the Balkans, because some of the cases actually were not very popular, including the cash crops and also the implementation of other legal schools, Shafi'i, Maliki, beyond Anatolia and Rumelia. So this jurisdiction, if we don't have evidence to the contrary, should be considered including Anatolia as the focus in my opinion.
Two, maybe a question and a comment. The slide with the picture of the phenomenon, or I'm not sure what it was. Keep going. One more. That's this.
So this
the
is,
English- no,
this
next
is the end of this
Yes,
document. Okay.
Okay, so in your language at the bottom, you call it imperial, say imperial order was issued in accordance with this noble fatwa. So how is it described? This is my question. How is it described? Is it described as a fatwa or is it described as a firman or amr?
This one?
In this document, what is this document formally speaking?
This document is a copy of the fatwas signed by Abu Suud. It clearly says here bu fetva-i şerife amel olmak için hükmü şerife verilmiştir. Bundan gayrı fetvalar hükmü şerife. Okay. İmzalı fetvaların suretleridir. These fatwas are the copies of the signed fatwas in the possession of the defterdar. The
What
finance.
about an imperial order was issued?
The hükmü hümayun verilmiştir.
So what is Hukm Humayun? What is that?
Hükmü imperial decree. Imperial decree.
So that's a decree. Is that synonymous with firman?
Yes, in this context, it is synonymous with that one.
Okay, yeah, now, so, thank you, that's my question. Now, my comment is sort of how to interpret this, because I think generally how to relate statutory law to judge-made law is like jurisprudential thicket.
Mhm.
So, like in the United States, we have a sort of similar problem. I don't want to get too much into details, but
Please.
at the founding of the American Republic, like one of the first statute passed was called the Rules of Decision Act. Very short, so I'll just read it. It says, the laws of the several states, except for the Constitution or treaties of the United States or acts of Congress otherwise require or provide, shall be regarded as rules of decision in civil actions in the course of the United States, in cases where they apply, right? So what does laws mean? This has been a subject of like 150 years of, well,
Mhm.
it became very controversial in the 20th century. Originally, what people thought it meant was the following, was that the common law as such, they called general law. And so they did not believe that laws in the statute had anything to do with the common law. They only applied to statutory enactments of different states. And so statutes by their very nature are very specific,
Mhm.
right, and exceptional.
Mhm.
And so they actually called it general law, which is very much like a fatwa, because a fatwa, if you look at usul al-fiqh, the definition is that it's shar'an, based on dalil am, right? So a fatwa by definition is universal, whereas a command is particular. And I noticed that the language in many of these is the judges are commanded, right? So it doesn't claim to direct the action of women. It doesn't say that women are prohibited from marrying themselves. It just says judges are prohibited from recognizing them, right? And so I think I would hesitate in calling imperial fatwa,
Okay.
because now you're sort of muddying the water, unless that's actually the term they use, because fatwa implies universal law,
Mhm.
because of the sort of fiqh background to it. Whereas decree or amr or something
Mhm.
is by definition specific.
So that's why I combine this specific thing with the, this is yeah, tafsir Yeah. So this is the definition of statute in the Black's Law Dictionary. Actually, I thought about it, but I want to get your opinion. It says a law passed by a legislative body, legislation enacted by any lawmaking body, including legislatures, administrative boards, and municipal courts, if you look at that part, it is like, modern state thing, legislative bodies and other things. But there is a code, in the same entry, where it says, we are not justified in limiting the statutory law to those rules on which are promulgated by what we commonly call legislatures. Any positive enactment to which the state gives the force of law is a statute. It continues, even the enactment of a single sovereign ruler can be categorized as a statute. So considering this, I thought that it might be applicable.
I think it is. I just think calling it an imperial fatwa is confusing it. Because the fatwa implies interpretation through legal science, whereas a statute is an act of will.
Actually, there is an interpretation here. It is not, consider the cashback case. The Sultan doesn't make the interpretation. The interpretation is by Hanafi authorities. So he just makes the selection.
Understood, but the interpretation, there always has to be an interpretation that the act of will is lawful. But what makes it binding is the act of will, not the interpretation, whereas with the fatwa, it's binding because of proper reasoning, not because of will. I'm sorry, I don't want to get.
Yeah. This is good. I'm just trying my hands. So I want to get your.
The binding quality of a fatwa derives from the persuasiveness of the evidence. Whereas the binding quality of this is because it's the command of the Sultan, right?
Yeah,
So
this is exactly what I want to underline,
and
that
that's why-
by adding an imperial to.
No, but that's why it's not a fatwa.
Okay, right. So the emphasis is on the fatwa in this case?
I just think it's misleading to call it a fatwa because a fatwa implies that it's persuasive because of the reasoning, or it's binding because of the reasoning, as opposed to the fact that it's the person who's making it, it's the authority of the person commanding it.
But they themselves call it fatwa.
Well, that's what I'm asking.
The fatwa
It's-
itself makes reference to the human beings.
Yes.
Like,
But just binding fatwas before.
Like, because it's the thing, like Hobbes, I think Hobbes, I'm sorry to go to Hobbes, but Hobbes has a very interesting discussion about the relation of natural law to civil law. So he says the entirety of the civil law is within the natural law, and the entirety of natural law is within civil law. So it's sort of like, snakes chasing each other's tail, because the commands are only valid to the extent that they are within what natural law permits. And so the same thing, that these commands are only permissible because they are permissible within fatwa. But their bindingness is not based on the logic of fatwas. They're binding because the person making the command is entitled to obedience. Whereas the mufti isn't entitled to obedience.
Yeah, I get your point. So do you have any suggestions?
Statute. Just go in the statute.
But then how are you going to differentiate it or distinguish it from the, common statute, karma? Without,
Why should-
not based on the,
Well, the definition you just said doesn't, I mean,
which one?
it's an almond or whatever that Persian word is. It's all statute, regulation, administrative.
But it is a statute based on fatwa.
But every.
So they took care to refer to the fatwa. It was for a reason, but you suggest just to disregard that aspect of this fatwa.
Okay. Let me try to use another analogy. Like in theory, before a legislature passes a law, it's gonna do a constitutional analysis to make sure that it's valid. But that doesn't make it an exercise in constitutional interpretation. That's just a condition for its validity. So the command, in order for it to be valid, has to be lawful from the perspective of fatwa, but it doesn't make it a fatwa, it's still a command.
I get your point. If I try to draw, a table of the legal norms, jurisdictional hierarchy of the norms, then I would go with your opinion. But my purpose here is to underline how or to explore how Sharia interacted with the imperial Farman and how the legal norms came out of the jurisprudential knowledge. And this is just only one chapter of this project, let's say. I'm going to focus on the fatwas of Shaykh al-Islam and how they were close to statute but not statute. And I'm going to focus, I'm going to talk about the imperial decree commanding to act in accord with Sahul Aqwal, which is again close to making the Sharia knowledge a statute, but not there. So this is the point which Sharia knowledge comes to this statute the most. For my purpose, I have to keep that aspect because my purpose is not to distinguish between different legal categories only, but also to show their relations with the other types of norms, moral or religious.
Thank you, Muhammad, and Dr. Rahman, for this engagement. It's very helpful. Maybe just call imperial law based on the French one, maybe easier. This is the plan.
Yes, thank you. Can we go to the first slide where you show difference?
Oh, sorry, I went the wrong way.
Yes, thank you. Here you wrote sources of authority in statute law is political power. But I think that here also the source is scripture, Nas, and Ayah and Hadith. Because if we look at the history, for example, at Kurdish capital in Ottoman Empire, Frederick, Kurdish capital, how did they justify this killing of small male relatives? They took two Quranic words, وَالْفِتْنَةُ أَشَدُّ مِنَ الْقَتْلِ, and the second one is وَالْفِتْنَةُ أَكْبَرُ مِنَ الْقَتْلِ. For example, I think always there is Quranic words for all sultanate decrees and farman and amr and everything. And for example, if we look at this 1979 revolt against the Saudi king by Juhayman al-Utaybi, and when he was captured, his leg and his hand was cut, and this is also based in Quranic verse إنما جزاء الذين يحاربون أو تقطع أيديهم وأرجلهم من خلاف. For example, because as far as I understand, in Islam, in Quran, there is no exact definition of hasad or mufsid or baghi. For example, there is this Quranic words وَإِذَا قِيلَ لَهُمْ لَا تُفْسِدُوا فِي الْأَرْضِ قَالُوا إِنَّمَا نَحْنُ مُصْلِحُونَ. And if everybody revolts against Sultan, they ask him, they say him, you are mufsid, and he says, no, I'm muslih, but there is another words.
Yeah,
So
actually, in this table, I just want to, present them as analytical categories, not applicable to specifically to the Ottoman case. So statute law everywhere, not only in the Ottoman Empire, but also in Europe, in the United States. What are its qualities? But you are right, in the Islamic world, in many cases, the statute laws, even though they originated from the will of the ruler, some people try to, provide justification on the basis of the Quran or the other scriptural sources. So you are right, I agree with you.
Thank you.
It's really interesting, thank you. A question, maybe I missed it, but can you comment on why the new Sultan would be asked to simply ratify the previous Mahudat rather than new ones?
So this is a good question. The Ottoman historians like to, let's say the old Ottoman historians like to see this as a sign of the entrenchment of patrimonial authority. Whenever a new sultan came to the power, old orders needed to be renewed to be applicable. But in this case, you know, it was easy to answer this question this way. In this case, I don't see that, you know, the new sultan, new bureaucracy or new government, let's say, he appointed probably new chief jurist, new chief judge, or, you know, strengthened relations with the old ones. And one of the you know, top scholars in the government wanted to benefit from this new environment or new conditions, and composed this work and wanted to get a ratification for the old ones and added new ones, in fact, in my opinion. But this idea is there. I don't agree with it. I think the Ottoman political order gained kind of impersonal nature. It continued, or some of the conventions became preserved, even with the changes of the Sultan. But this idea that the Ottoman political power was a patrimonial, and when the Sultan changed, and the old rights and appointments needed to be renewed to become effective is there. But I need, I want to engage with this idea in my forthcoming book.
I think Ryan Katz disagrees on the follow that point.
No.
Are you sure?
Peace.
Okay, thank you so much.
Thank you.
Finally, our final presenter is Hussein Salal. PhD student at Istanbul University and currently visiting researcher in Texas with me, one who did not Hussein personally. The title of his presentation is The Early Hanafi Literature on Inheritance Law for Texts and Contributions.
Thank you so much. I'd like to begin with thanking to our host and also Professor Sami for giving me this opportunity. And today I will discuss a significant yet often overlooked subject of Islamic legal history, the inheritance law. The 6th century marks an important period in the development of inheritance law. In this era, important inheritance works emerged, such as Sirajiyya, Rahbiyya, and Hawfiyya, which represent the Hanafi, Shafi'i, and Maliki schools respectively. These three texts have become classics in the field of inheritance law within their legal traditions. Particularly considering Sirajiyya, it's noteworthy that after its composition, commentaries and hundreds of hashiyas were written, many of which are existing in Ottoman libraries today. But even though the 6th century is an important period, it's crucial to acknowledge the rich tradition of inherited literature that predates Sirajiyya within the Hanafi school. Many poetic and prose inheritance works existed during this earlier period, reflecting the inherited interest in this topic among early scholars. By examining the period prior to the 6th century, we can better understand this sustained interest in inheritance law, which has continued beyond the early period and continued in subsequent scholarly. In this presentation, my research question is why numerous works have been written on the subject of inheritance law and what original contributions these works have made to the field. As a case study, I will focus on 3 poetic inheritance treatises found in Ömer Nesefi's book, Matla'un Nujum,
which compiles 56 different works related to 23 different sciences. Firstly, to see the early content of the inheritance law, I will talk about the Fara'id chapter in Imam Muhammad's Kitab al-Asl. Following this, I will briefly introduce the Matla al-Nujum, and finally I will address the 3 inheritance treatises found in Matla al-Nujum and their importance about early Hanafi inheritance law. Despite having relatively few disputes and its issues being quite clear compared to other areas of Islamic law, inheritance law has attracted significant interest since the early periods. Even before the formation of the Islamic legal schools, it's said that some Sahabis and Tabi'is, such as Zayd ibn Sabit and Sufyan al-Thawri, authored works on inheritance. However, the earliest known work that comprehensively addresses inheritance issues is Imam Muhammad's Kitab al-Asl. The structure of inheritance law in Kitab al-Asl is somewhat different compared to subsequent fiqh books. While Kitab al-Asl contains provisions and numerous examples, later works introduced a systematic structure that begins with the actions required after a person's death and finished with the scenarios involving multiple deaths at the same time. The structure of the Fara'id in Kitab al-Asl likely originates from Shabi's collection on this topic. Shabi, a leading scholar among the Tabi'i, contributed to the development of Kitab al-Fara'id, and his narrations of the companions' views on Fara'id have been transmitted to us through Kitab al-Asl. In the beginning of the Fara'id section, Imam Muhammad cites from Shabi the views of companions and tabi'ins on inheritance matters, and he provides examples for these views and expanding them with detailed explanations. Kitab al-Asl directly begins with scenarios detailing the inheritance shares of various relatives, such as fathers, mothers, sons, daughters, and siblings. It then goes on with the famous problems in inheritance law, such as the grandfather's inheritance, the issue of rent in inheritance, and the aw, which means the situation when nominator is higher than the denominator. The Fara'id section in Kitab al-Asl is likely one of the parts of fiqh that includes the most opinions from the Sahaba and Tabi'in, alongside the topics of worship, the Ibadah. This section is filled with the disagreements among the Sahaba regarding inheritance matters. It highlights the views of prominent figures in inheritance law, such as Zayd bin Sabit, Abdullah bin Mas'ud, and Ali bin Abi Talib, on issues not addressed in the Quran. After covering the main issues of inheritance and providing examples of how to divide estates in these problems, Kitab al-Asl opens a chapter that is not commonly found in subsequent fiqh texts. Imam Muhammad introduces the باب ما يسأل عنه الرجل من مشتبه الفرائض مما يكون من غير ولاء ولا مجوس. That chapter on complex questions asked to a person about fara'id that do not involve kinship from slavery or Magian kinship or Majusi kinship.
I think you need to go through.
Okay. The questions in this section evolve into what are known as fiqhi riddles or al-ghaz. These riddles are characterized by their intricate situations involving family relationships that are not immediately obvious. The intention behind these questions is to encourage readers to engage deeply with the issues and practice solving complex problems. They are designed to challenge to the reader to consider how specific familial relationships might exist to resolve the presented problem. This requires expressing relationships in unconventional ways, dealing with complexities arising from marriage ties, or finding the exact kinship relationship within the given scenario. The exclusion of examples involving Majusi kinship or slavery is important because Majusi kinships could involve incestuous marriages and kinships arising from slavery can create complex scenarios. That's why these riddles do not include examples of such problems, such relationships, focusing instead on more conventional but still challenging inheritance problems. To better understand this, we can look at two very simple examples from the Kitab al-Asl. The first example states, ولو أن رجلا سئل عن رجل مات وترك خال ابن عمته ولم يكن له خال غيره وترك عمة ابن خاله ولم يكن له عمة غيره فإن هذين أبوا الميت. A man is asked about a man who died and left behind the maternal uncle of his cousin, and he had no other maternal uncle, and left behind the paternal aunt of his cousin, and he had no other paternal aunt. The solution is, the problem is, these two are the parents of the deceased. And in the second example, if it is asked why one of the two siblings who share the same mother and father inherits from a man while the other does not, the answer is that the deceased is the son of the inheriting sibling and the other sibling does not inherit anything from him. Yes, these are pretty easy, by the way. These examples demonstrate the intricate nature of the questions and illustrate how they compel the reader to apply their understanding of inheritance law to complex and often abnormal family situations. This method not only helps in mastering the principles of inheritance, but also enhances problem-solving skills by presenting challenging scenarios that require deep attention. As Ibn Khaldun observed, that early inheritance works included both fiqhi rulings and detailed calculations. These early texts placed significant emphasis on various scenarios and the corresponding calculations. Consequently, this branch of fiqh evolved into a distinct science in later periods. Ibn Khaldun pointed out that in various math calculations and the resolution of hypothetical issues became main concerns. He noted that many scenarios presented in these works were highly improbable in reality. This inclusion of these rare or peculiar examples was intended to provide practice for those wishing to deepen their understanding of inheritance law. This observation by Ibn Khaldun is also evident in later Hanafi works. In many detailed Hanafi fiqh books, the Farais no longer appears under the main chapters. Notable books such as Al-Hidayah, Bada'i al-Sanaya, and Durar al-Hukam, which have had numerous sharhs and hashiyas written on them, do not contain a Kitab al-Farais section. Instead of these books, we see in biographical dictionaries, bibliographic books, and manuscript libraries that many scholars wrote different types of risales, sharhs, and hashiyas on Farais. Although the rulings on this topic are largely detailed in the Quran, and there are relatively few disputes compared to other branches of fiqh, the works produced very significantly. They differ in format, the topics they cover, the level of detail provided, and the techniques used for calculations. Some works even include tables to facilitate easier inheritance calculations. Although the content of these works not differing drastically, their form, the detail of the topics they cover, and their approach to calculations distinguish them from one another. The practical nature of inheritance law led to individuals seeking to improve their inheritance calculation skills, motivating scholars to produce various texts on this subject. After providing this information about the Farai section of Kitab al-Asl and the early Hanafi literature on inheritance law, now I would like to give some information about Matla al-Nujum, where the three inheritance poems exist. Matla al-Nujum was written by Omar Nesefi towards the end of his life. In the introduction, Nesefi mentions his intention to compile a book that would be easy for both beginners and advanced scholars, encompassing works from various sciences. This comprehensive collection includes works from the genres present during Nesefi's time. Madda Nujum covers a wide array of subjects, including Aqeedah, Tafsir, Hadith, Fiqh, and Arabic language. Additionally, it includes treatises on poetry, astronomy, astrology, mathematics, and occult sciences. Although it spans 23 different branches of knowledge of sciences, each work within the book covers subfields of these sciences. For instance, under the category of fiqh, this genre includes furu al-fiqh, usul al-fiqh, khilafiyat, sukuk, etc. Out of the 56 books contained within Matla al-Nujum, 36 were authored by Nesefi himself, while the remaining 20 were written by other scholars, whose names explicitly mentioned. These three inheritance treatises include in Matla al-Nujum were not written by Nesefi himself, but by other scholars. The first of these treatises is Nadm al-Fara'id, authored by Abu Mansur Mahmud bin Ali al-Muhallabi. There is very little known about al-Muhallabi. The only information I found about him was in Sa'alabi's Yetimet al-Dahr. Sa'alabi's work compiles poets and their poetry up until the year 400. While the information about the poets' lives is limited, the focus in the book is primarily on collecting their poetry. In the section where Sa'alabi discusses the poets of Khorasan and related cities, he mentions al-Muhallabi. From this work, we learn that al-Muhallabi served in the Divan al-Rasail during the final years of Samanid era alongside a group of scribes. Sa'alabi describes al-Muhallabi as Ash'ar al-Qawm and provides examples of his poetry. It is interesting that a person who served as a scribe in the Samanid state wrote a treatise on inheritance law, and that Nesefi chose to include this treatise in Matla al-Nujum. This inclusion may demonstrate that during this period, it was possible for a scribe to continue his scholarly pursuits and even while holding a bureaucratic position, which we don't see generally in Ottoman era. Muhallabi's Nadm al-Fara'id consists of 180 couplets. In the opening lines, al-Muhallabi states that he composed this work in verse, in Nadm, to make easier the memorization. However, beyond this practical reason, he does not provide further justification for writing the treatise. Al-Muhallabi begins by discussing the first steps to be taken before dividing the inheritance, and then lists the individuals entitled to shares. After mentioning the Ashab al-Fara'id and the Asabah, he details the shares of 2/3, 1/2, 1/3, 1/4, specifying who receives this portion under different circumstances. Following this, he addresses well-known inheritance issues like Ekteriya al-Umariya, and similar to Kitab al-Asl, he includes complex inheritance puzzles and examples of family relationships. These puzzles are the poetic versions of what we found in Kitab al-Asl. For me, the most interesting aspect of al-Muhallabi's work in his inclusion of these alghaz riddles. By including these intricate issues, al-Muhallabi ensures that students not only memorize the rules of inheritance, but also memorize these complex cookie puzzles. Apparently, for him, memorizing such riddles was also an integral part of learning Fara'is. Nesefi's inclusion of this work in Matla al-Nujum suggests that it was either considered to have a beautiful versification among the inheritance risales of that period, or was one of the prominent inheritance treatises of the time. However, we don't see references to either al-Muhallabi or his work in later literature. Another indication of the work's limited circulation is the absence of its manuscripts in many manuscript libraries. The only copy of Nazm al-Faraid that I have been able to identify, apart from its inclusion in Madl al-Nujum, is found within a collection at the Bursa Manuscript Library in Turkey. This scarcity of copies highlights the work's limited reach and that it did not gain widespread recognition or influence in subsequent scholarly traditions. Within the Hanafi school, the work that gained prominence in later periods was Sirajiyya, authored by Sirajuddin as-Sajawandi, who passed away approximately 60 years after Nasafi. Sirajiyya became the most widely recognized treatise on inheritance law, as evidenced by the over 70 commentaries and hundreds of hashiyas found in Ottoman libraries. It's clear that Sirajiyya became the most widespread inheritance work after the 6th century in Hanafi literature. Similarly, the inheritance works by the Shafi'i jurist al-Rahbi and Maliki jurist al-Hawfi, who lived around the same period as Sajawandi, significantly influenced the inheritance literature within their respective schools. Although al-Rahbi belonged to the Shafi'i school, his work on inheritance is particularly noteworthy because, like al-Muhallabi's treatise, it is composed in nazm. The fact that al-Rahbi's work was written in a field with minimal dispute between school of laws and versified the issues of inheritance in an easily memorable way, contributed to its fame not only within the Shafi'i school, but also among the other legal traditions. At this point, my question is, why does a particular work on Farais become widespread among scholars, while other works do not achieve the same level of recognition? Or put differently, why did Rahbiya gain such fame while Nazm al-Faraid did not achieve the same attention among scholars? To answer this question, I will briefly compare the two poetic works on Farais, Nazm al-Faraid and al-Rahbiya. When we examine Rahbiya and Nazm al-Faraid, both consisting of 180 couplets, the first observation is that both texts largely address the same fundamental issues of inheritance law. This is due to the relatively low number of disputes in inheritance law compared to other areas of Islamic law. However, despite this common ground, the two texts differ significantly in their coverage of topics. Both works start with the fundamental issues of inheritance law, such as Ashab al-Faraid, Asaba, share ratios, disqualifications from inheritance, and other inheritance impediments. The divergence between the two texts begin with the methods of inheritance calculation. Rahbiya explains mathematical operations like increasing the denominator to a larger number or reducing it, whereas these topics are not found in Nazm al-Faraid. Another significant issue related to calculations is the munasakha. This process, which involves the death of an heir before the distribution of the inheritance, is one of the main issues in inheritance law. While munasakha is mentioned in Rahbiya, it's absent from Nazm al-Faraid. Moreover, Rahbiya includes couplets on mafqud persons, pregnant women, and hermaphrodites who are mentioned in inheritance law due to their uncertain status. These topics again are not present in Nazm al-Faraid. Finally, Rahbiya addresses scenarios such as drowning, burning, and accidents, where the simultaneous death of people creates uncertainty about the order of death, posing challenges in inheritance distribution. Apparently, Muhallabi did not include some of the fundamental issues of inheritance in his work. One of the most notable topics found in Nazm al-Faraid but absent in Rahbiya is the famous problems of inheritance law such as Osmaniyya and Minbariyya. These are complex questions which became famous since they asked the companions and they resolved by them. While Rahbiya mentions issues like Ekteriya and Musharraka, it doesn't address other similar complex questions. Furthermore, Nazm al-Faraid dedicates 22 couplets to fiqh puzzles, a topic not covered in Rahbiya. Muhallabi included these complex exercises in his work, whereas Rahbiya explicitly states that it doesn't contain such puzzles. Rahbi says, فَهَاكَ فِيهِ الْقَوْلَ عَنْ إِيجَازٍ مُبَرَّأً عَنْ وَصْمَةِ الْأَلْغَازِ. To sum up, the reason Nazm al-Faraid did not gain widespread recognition in later periods can be attributed to its exclusion of fundamental issues in inheritance law. Instead, it devotes extensive coverage to fiqhi puzzles, which are not directly related to rulings of inheritance law, but are meant to strengthen calculation skills. On the other hand, the fame of Rahbiya can be attributed to its concise and elegant treatment of all of the important topics in inheritance law, while excluding unnecessary subjects. The second and third inheritance treatises within Matla al-Nujum continue precisely from where Muhallabi left off, focusing on Al-Ghaz literature. The author of the second inheritance treatise, Abu Najah Muhammad bin Mutahhir, is the most renowned among the writers of the inheritance treatises in Matla al-Nujum. Scholars such as Qadi Iyad, Ibn Maqula, and Ibn al-Jawzi provide information about him in their biographical works. Abu Najah, also known by his epithet Faradi, lived in Egypt and was a Maliki jurist. It's mentioned that Abu Najah authored 4 works on inheritance law. Qadi Iyad notes that Abu Najah composed poems on inheritance in a form called Mu'ayat. And the poem included in Matla al-Nujum is an example of this, as we can see from its title. It's interesting that despite being a Hanafi scholar, Nasafi included a fiqh work by a Maliki in his collection. Given that Abu Najah's work primarily comprises Al-Ghaz questions, which are more related to kinship relationships, but not related to fiqh provisions. It can be inferred that Nasafi did not hesitate to incorporate this treatise into his work. Abu Najah's work, Masail Mu'ayyat al-Faraid, includes poetic questions and answers, as well as a prose explanation of these inheritance puzzles. Although there are subtle nuances between them, terms such as Al-Ghaz, Muhajat, Malahin, and Mu'amma are also used with the same meaning as Mu'ayyat. We see that many Al-Ghaz risales were written by scholars, and after a certain period, due to its significance, Al-Ghaz also become one of the main sections in works of Ishbah wa Nadair. There are also Al-Ghaz books that cover all chapters of fiqh, as well as several works that focus on specific chapters of fiqh, such as Kitab al-Nikah or Farais. The primary purposes of these works include practicing, testing, and demonstrating the intricacies of the issues. Abu Najah's work, Masail Mu'ayyat al-Faraid, contains 12 fiqh puzzles. In these puzzles, each scenario is first presented in verse form as a question, followed by a poetic answer. After the question and answer, Abu Najah provides a prose explanation of the issue. The questions typically describe the relationships between certain individuals where one person is expected to receive an inheritance share but does not receive, and another who is not expected to receive a share but he does. The explanation seeks to illustrate how this is possible. In the answer section, it's revealed that there are additional kinship relationships not mentioned in the question, which influence who can inherit and who is excluded. In the prose explanation following the answer, Abu Najah sometimes indicates that there are multiple solutions to the problem, and he elaborates on each possible solution individually. The final inheritance treatise I examined is by Ali bin Muhammad al-Nasafi. Nasafi's work is, in a sense, a continuation of Abu Najah's poem, even the title Masail min jinsiha nadamaha Ali bin Muhammad. The original title given by Ali bin Muhammad for his work is not mentioned. Like Abu Najah's work, this is also of the Elghaz genre. I couldn't find any information about Ali bin Muhammad, the author of this poem, in the sources, but this treatise contains a total of 21 issues consisting of poetic questions and answers like this one. Conclusion. In conclusion, the Hanafi tradition of Fara'id works begins with Kitab al-Asl, which provides legal provisions alongside numerous examples to illustrate these provisions. The Elghaz tradition also originates with Kitab al-Asl, featuring complex inheritance puzzles that do not include legal provisions but serve to enhance the problem-solving skills related to inheritance issues. Another observation is that from the early period, there have been diverse types of inheritance works. These works can be in verse or prose, addressing legal provisions comprehensively or focusing on specific topics and excluding others. Furthermore, Nesefi's work, Matlar Nujum, shows that Elghaz were an important part of Fiqh education. The inclusion of these puzzles in his work indicates that his intention for students to memorize complex legal problems, develop their problem-solving skills, and become familiar with this genre. Thank you so much.
Okay, thank you. Any questions?
Something simple and
Yeah.
mostly like mama.
Alright, I'll start out with something simple and related to the matla. How do you know that he composed the matla and Najm towards the end of his life? How do you know that he composed the matla and Najm towards the end of his life?
It's a good question. He, in the introduction part, he mentions that he's become like an old one like that. In the introduction, he mentions.
Aish?
Sorry if I missed this, but, can you talk more about the, maybe some of few words that don't include a chapter on Fara'id? Do we know why they don't have these chapters?
As I saw from the literature, both by Hidayah or Durar Durar, not Durar and Bidari was Sanai, or and today Al-Uqaya also, for instance, it doesn't mention any Fara'id section. These works are excluded the Fara'id because it's like it's something special right now, and there are this literature is excluded from fiqh works, and people wrote mustaqil Fara'id works, and they make lots of practices on these works, not in fiqh text, because there are lots of calculations and scenarios and etc. And it makes the fiqh books very longer, and that's why they exclude it.
Okay.
But I forgot to mention Said Ekber. Mr. Said Ekber is the one who published the manuscript of Matlar, and thank you.
I want to know about the Rampur Nusqa. You now enter this Nusqa, and did you take this Nusqa and comparable with Pashto Nusqa?
Yeah, I also got it from Rampur, and it's an earlier manuscript from Tashkent Nusqa, but it's some of the parts of this Nusqa is missing, like first maybe 5 treatises about Aqidah or tafsir, not tafsir, qira'at or etc. It doesn't exist in this manuscript. And also the last part of this manuscript also missing. But when we look at the scribe, it says I copied this manuscript from Ibn Omar al-Nasafi. And it's a very early manuscript.
Okay, I think we'll stop here today. Thanks so much. Okay, so here's the plan for tonight. We're gonna go for a very brief visit to the Hadith Studies Institute across of us here, and then we're gonna head directly to actually dinner, and then go home to sleep. Thank you. The plan for tomorrow is a visit in the morning, we'll visit in the morning that I shared with you on the WhatsApp. I think you will be able tomorrow.
Are you going to?
Okay, so the visit in the morning, and then they're gonna come here at 10. There's a reading session, have a reading session, I'm not sure if those within the report. There's 2 or 3 texts that we're gonna be reading. One of them is gonna be a contract, very early contract from Samarkand that read, inshallah, by أخونا قادر قضية يلماس and نص من الأسرار مع محمد الشاهين وقضية من المحاكم الشرعية إن شاء الله معي لو وقت يسمح. وبعد ذلك نذهب إن شاء الله إلى الغداء، وبعد ذلك نذهب إلى البازار للصعلكة، تمام. وسوف نذهب غدا في المساء إلى بخارى، تمام. الساعة 8 إن شاء الله سوف يأتي. So tomorrow 8 p.m. sharp, there's a bus will take us to the train station. Yeah.
So should we be like having this weekend so that we can check out?
We are paying for the night, even though we're going to be here. Yeah.
But we can.
Yeah, just leave your stuff in your rooms until here. You're welcome.
So we'll go back to the hotel after the tour in Samarkand tomorrow.
Tomorrow the dinner is optional. So basically we're gonna finish everything here, go for lunch. After that, it's gonna be bazaar. We're gonna go. There's also a free tour. Those who have not been to the Rajasthan and the Rosalan, we might go. Yes, yeah. Well, free to go wherever we want, but we must be at the hotel tomorrow with the bus that picks us